but according to my watch,
Oh, yeah, we're 1 minute.
Who?
according to this, it's 9:31.
I asked
Want to call the finance meeting to order, and the first order of business is roll call.
Coel is absent with notice. Zach?
Here.
Long?
Here?
Taub? Here. Fleming?
Here.
Crawford?
Here.
Woodward is absent with notice. Bowman? Here. Middleton?
Here, we have a quorum. First order of business is the pledge to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Next is, I need a motion to approve the minutes of the previous meetings of January 25th and February 1st of 2018. Fleming is moving it, Zach is supporting it. Any discussion on the minutes? If not, all those in favor signify by saying aye.
Aye.
Opposed, the same. Motion carried. Next is the presentation of the agenda, and we have a couple issues. We have a walk-on, which is a report from the TIFA committee, so we need to add that as item number 37 to be taken up after item 28. So the TIFA report is going to be item number 37 on our agenda. Second is a memo from L. Brooks Patterson to be added under other business. Number 3, a notice of a hearing to be added to communications item G. And then public comment. So now we will go to public comment. But before we start that, I'm going to take up item number 27 and 28 have to do with the sheriff's contracts, which we're going to accept in the consent agenda. So I'm going to take 27 and 28 after the contingency report. I'm going to take 27 and 28. Then we're going to go to the consent agenda and accept all those contracts that have that wording in it. And then when we go back to the regular agenda, we're going to take the walk-on, the TIF walk-on number 37. And then we will follow the agenda as was sent to you. So I've got a cheat sheet up here. Yeah. Okay, so with that, we will do the contingency report. I need a motion to receive and file the contingency. Taub is moving it, Wade is supporting it. So go ahead with the contingency report.
Good morning. On page 1 of the contingency report, which is page 13 of your PDF, we have a general contingency balance of $53,073. There are no items on today's agenda that impact that amount. We go over to page 6 of the report, which is page 18 of your PDF, under miscellaneous capital outlay. There are 2 items, 2 approved memos, one for the Board of Commissioners, a replacement of the AV control system for $5,042, and Sheriff's Office oven replacement for $69,535, leaving a balance of $532,612. Then on to page 9, which is page 21 of your PDF. There is an item, item number 1 on the agenda is a tri-party for the Charter Township of Springfield in the amount of $37,000. And then on the next page, page 22 of your PDF, there are 3 more items. An additional tri-party appropriation for the Charter Township of Oxford in the amount of $36,606. And then item number 34 on the agenda for the Board of Commissioners, the sponsorship of the bocce tournament for $12,000. And then item number 35, funding support for Havens Conference for Domestic Abuse Professionals in the amount of $4,000.
Okay. Any questions on the contingency report? If not, all in favor of receive and file signify by saying aye. 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 Opposed, the same. Motion carried. Pam informed me that I had skipped over public comment, so I'm going to have to add public comment in. Andy, did you want to do public comment Just real short, okay.
Thank you. Just briefly, I want to spill the beans about the ad hoc committee's work that's going to be before the committee in a moment, but I just wanted to take a moment to really congratulate my colleagues at the county and at the city of Southfield and the Southfield DDA on some really constructive collaboration around redevelopment of the Northland property. The ad hoc committee approved, I guess, took us an important step towards participation on the part of the county in a tax capture for what is a very exciting redevelopment of what I think is one of the most significant parcels, not just in Southfield, not just in Oakland County, but in the entire region. And while it does come at a cost to the county, I see that as a very sound investment. And really want to acknowledge Commissioner Quarles, Commissioner Jackson, Joanne Shorley, Dave Heber, and Dan Hunter with the Economic Development Team. I think seeing that spirit of collaboration around such a important challenge should inspire the citizens of Oakland County to know that their county government is really working for them. So thank you.
Okay, thank you, Andy. Is there any other public comment? If not, we'll move on to communications. I need a motion to receive and file communications A, B, C, D, E, and F, and didn't I add one? And G. Is there, Fleming is moving it, Zach is supporting it. Any questions on communications? If not, all those in favor of receive and file communications signify by saying aye.
Aye.
Opposed, the same. Motion carried. Thank you. Next, we're going to go to the regular agenda for items number 27 and 28. And the reason we're taking those up because they have reports that go with them, and it changes. So it couldn't be on the consent agenda. We have to accept the reports.
Okay.
And then they pertain to the items on the consent. So, need a motion to accept, to consider item number 27. Bowman and Tom. Yes, okay, and you have a question on 27?
There's, it says amend middle and last sections of Schedule A in the report, and it says the total revenue increase. Is that what it is?
What's your question, ma'am?
Okay, item number 27, there's some dollar amounts scratched out.
Yes.
And is there a revenue increase or revenue decrease?
That's a revenue increase overall. What happened was I made a mistake in the initial, contract with the city of Pontiac. So what you're seeing there is a reduction in the cost for the city of Pontiac, which will also reduce our revenue. But from the original, set of contracts, yes, we're having a $250,000 increase in revenue.
Okay, thank you,
Okay,
Mr. Chairman.
Commissioner Long.
Okay, good morning. I was at the Commerce Township Board meeting, and there was some discussion about the rates going up. But I said you get excellent service, and you couldn't do it yourself, you know, they called on me then. But, so, are the rates going up because of raises? Is
Rates
it
are
for
going
the
up.
employees?
Rates are going up because costs have gone up. And in Commerce Township, along with several of the others, their calls for service for fire have gone up tremendously. So when we average over 3 years, we come up with an average as the formula we use, and then it is what it is. And a couple of communities were about the same. There was a base increase of what, 4%, was it?
Yeah, 3.7.
3.7%, and then,
Okay.
so that's the rates period. And then, if last year, let's say you had 1,000 calls, and over the last 3 years you had 1,200 calls, well, you're gonna go up 20% as a result of that.
Okay, so it was based on their usage?
Correct.
Because I think
It's
they said it was
based on
going
the
up in
rate-
3
the
years,
rate
like
that's
$1,000 more
established.
dollars a
Right.
month or something, so
So
there
the
was
rate that's
discussion.
established per call, And then if your calls increase, your cost goes up. If your calls increase, then your costs would go down other than the inflationary
All right, so
increase.
radio replacement is not anything to do with this cost, or it is?
Radio replacement doesn't have anything to do with this.
Okay, because they were saying that, and I said, I think that's the wrong way.
No,
They're
no.
going, okay, well, they voted for it, but
Okay.
there was discussion about the rate increase. Okay, thank you.
Okay, yes, Commissioner Bowman.
If you could you just clarify that prior statement? You said that there was a modification. Of the
I'll cover for him. His calculator was broken. Actually, it turned out to the benefit of Pontiac. Pontiac's unique from the other fire dispatch contracts. And the reason it's unique is that we do emergency medical dispatch for the city of Pontiac. When you dial 911 in Pontiac, you get the sheriff's office dispatch. Okay, the fire department, as you know, is the Waterford Regional Fire Department, which is Waterford contracts with the city of Pontiac, Pontiac contracts with the city of Waterford for fire protection. So if it's a medical emergency, we go through that protocol. We tell them how to start CPR or save a choking baby or whatever. If it's just a flat fire call, we transfer it to Waterford. If it's a medical emergency, we handle the EMD and we transfer the call to Waterford at the same time so that they can respond, the fire department can respond. All the other fire departments we dispatch for, we do EMD, and we obviously are the fire dispatch. And this is unique because it's a separate fire department doing the fire service. So Dale, when he calculated it based on the fire dispatch rate versus the number of EMD calls, emergency medical dispatch calls. Which when you're doing 18, 19 contracts, you just, you kind of go through them all, and, Dale's a good guy.
Sometimes.
Okay.
We got it.
Okay, Commissioner. Dave, you all set? Okay. Any other questions on this? We have to first do a report to accept the changes that are on the resolution as originally. And that changed the date to March 31st, 2021. The 254 that Commissioner Taub talked about, and which then changed the total at the bottom. So, first we need a motion to call the roll on the report. Need a motion to accept the report. Taub is moving it. Zach is supporting it. So on the report, the roll call.
Long,
Yes.
Cobb,
Yes.
Fleming,
Yes.
Crawford,
Yes.
Bowman,
Yes.
Zach,
Yes.
Middleton,
Yes, motion carried. Now we'll vote on the motion itself on the item 27. Call the roll.
Zach,
Yes.
Long,
Yes.
Cobb,
Yes.
Fleming,
Yes.
Crawford,
Yes.
Bowman,
Yes.
Middleton,
Yes, motion carried. Next, we have item number 28, emergency medical dispatch service agreement with the city of Pontiac. Commissioner Bowman is moving it. Commissioner Taub is supporting it.
Yeah, I just explained, the commissioner asked the question, so I
Yeah.
kind of got ahead of myself, but the explanation I gave you is the reason why it is what you're seeing before you.
Okay, and any questions? And again, we have a report because we have a change in numbers. I need a motion to accept the report. Taub and Zach. So now, on the report, call the roll.
Fleming,
Yes.
Crawford,
Yes.
Bowman,
Yes.
Zach,
Yes.
Long,
Yes.
Cobb,
Yes.
Middleton,
Yes, motion carried. Okay, now we need a motion on the resolution. And we already have the motion, so we need to call the roll.
the fiscal note, Zach,
Yeah.
Yes.
Long,
Yes.
Cobb,
Yes.
Fleming,
Yes.
Crawford,
Yes.
Bowman,
Yes.
Middleton,
Yes, motion carried. Okay, now
Thank
I'm going to move to the consent agenda. And the consent agenda is items number one. Number one is a tri-party, but then from there on, 2 through 26 are sheriff contracts. And I'm going to move those as one item on the consent agenda. So I need a motion to accept the consent agenda. Long and Taub. Any discussion on the consent? If not, call the roll on the consent agenda.
Crawford,
Yes.
Bowman,
Yes.
Zach,
Yes.
Long,
Yes.
Cobb,
Yes.
Fleming,
Yes.
Middleton,
Yes, motion carried. Thank you.
Thank you.
Next is,
Can I take just a minute? I wanted to thank management and budget. I work on these contracts a lot, but really Terry and Gay and Lynn really assists me in that. And then actually even Michael, thank you, because he also assisted me in finding one of my other errors that you guys didn't see. So thank you.
Okay, thank you. Next, we are going to go to the walk-on item, which is item number 37 that's presented.
All right, so we do 27, 28.
It's a walk-on, but everybody was emailed last night the content of that, so it is a walk-on, but you've had a little bit of heads up of what's coming. So item number 37 is the agreement with Southfield, and I need a motion to accept the resolution. The title is Participation in the City of Southfield's Downtown Development Authority. And Zach is moving it, Fleming is supporting it. Go ahead, Al, or?
I'll do some introductions.
Okay, go ahead.
Good morning. Dan Hunter, Deputy Director, Economic Development. Joined here by Fred Zorn, Southfield City Administrator. Alice Sevis, Executive Director of Southfield Downtown Development Authority. And John Jackson with McKenna & Associates.
Okay, and we have a blue sheet on it also. So, okay, go ahead.
With that, I will turn it over to Fred and Al to give a snapshot of what's going on around the Northland Center, which is a key part of the district.
So,
I think most of you are aware that the city of Southfield recently acquired the Northland site after some extensive conversations with different representatives from the private company. In fact, even Al Taubman, 3 days before he passed away, we had engaged his advice and counsel on this. As the mall was in bankruptcy, we were able to acquire the mall. The Macy's store was donated. We still had other department stores to deal with, the JCPenney's, some outlet pieces. We're nearing, and we have, for the most part, completed 100% of the assemblage of the mall. Asbestos abatement and environmental cleanup has begun. A brownfield plan has been approved. The site, however, and what is in front of you, sits in our Downtown Development Authority, which, unlike a lot of DDAs across the state, we were underwater and had been for a while. So I'm going to let Al address and speak regarding the DDA and the restatement of the DDA.
During the economic decline over the last 5 years, the DDA's valuation on buildings dropped tremendously. It dropped even further once the Northland Mall came off of the tax rolls. During that same time, as you know, there were many tax tribunal awards that were awarded back to the taxpayers that forced us to repay close to about $1.5 million back from our fund balance. And so currently, when the TIF was established, the valuations were approximately $104 million. Today, they're around $69 million. However, with the excellent opportunity of the Northland redevelopment, we need to get ourselves corrected so that when the development begins to move forward, we can at least begin to have cash flow going positive rather than negative. So once the city acquired it, we were then hired a master plan by OHM to present back to the city a concept plan that includes residential, some retail, medical. There's an area that is allocated for parks and stormwater retention, which functions as a pool area. And so we're very excited about the opportunity. The city has committed $20 million to this project. We have approximately $8.3 million into it as we speak. As Fred mentioned, the asbestos will be completed probably first week, second week, let's see, we're in February, March. I would say by the end of this month. And then we'll begin to let out requests for proposals for the balance of the mall. We have started the demolition. We have 2 small pieces that have come down. And so the opportunity to partner with the county and allowing us to capture 100% under the TIF is sorely needed and greatly appreciated. And you know, we'd like to thank the TIF Ad Hoc Committee for their support earlier today and allowing us to move forward before this body.
And Mr. Chairman, if I may also
Yes.
add, the planning process, this wasn't one of these where local government brings in the planners that just does the dreaming. We actually brought in various market consultants, the Danter Group, which is well respected by the finance community in southeastern Michigan, as well as in New York, as well as Robert Gibbs of Birmingham, a market consultant who does work internationally and around the country. So this was a market plan driven. What's interesting about this plan is it actually, since ALS Evis has come in on our DDA, our focus has been the eds, the eds and the meds and the shopping. Well, obviously, we've lost a large piece of the shopping as the world is changing the retail environment. But the eds focus has been a solid partner, but what's most exciting is the meds. 3 years ago, AL took his DDA to Grand Rapids. Out of that came a partnership with MSU that's now producing 196 physicians are being trained at Providence Hospital. Prior to that, the hospital had an arrangement with a Caribbean school, med school, and they were about 50. So you're producing about 250 physicians are being trained on site. The hospital's always been a teaching hospital until the Beaumont acquisition in Southfield, which will now become the largest employer in Southfield. Providence Hospital was our largest employer. So working with Medical Main Street and just that payoff, and then obviously the city, we enjoy a very strong relationship with Lawrence Tech, and under the leadership of Dr. Modgill, LTU is now producing and created a new nursing program to produce 50 nurses. We're extremely excited about the synergy that we'll see with the university and the hospital. As we've been going through the planning stages, we are actually working with the medical REIT out of California. And the next Tuesday, we are going to see some very exciting things. Al and I have seen some of the preliminary, but we will, for the first time, see this move from vision to, within a year, we'll be able to see sticks and structural steel going up. And I think this is exciting for southeastern Oakland County. The county grew up, with the migration of the mall and from Detroit. We watched it move to Oakland Mall and now Somerset, Great Lakes, and this is our marketplace in play. I also want to comment that most of the brownfield activities are focused on infrastructure and demolition. And if one looks at the last 20 years worth of tax collection that the local unit of government collected, we will not even cover the full demolition environmental abatement. And there is the anatomy of that demolition, whether it's a single-family home run with the demolition of 15,000, the last 15, 20 years worth of taxes collected by the local government doesn't cover it. It holds true in the mall situation. And it's a cultural shift I think we need to be aware of. The brownfield legislation does provide us a tool to work with that, and we appreciate your willingness to work with our DDA and our brownfield authority to move this project forward.
Okay, thank you. Dan, did you want to
Just a comment, this definitely ties in from an economic development perspective. Fred had mentioned the Medical Main Street with OCC being there and a nursing program, and retaining and helping to grow Providence. I like the fact that a master plan was done, and that market analysis for various sectors was also done. So it's not just something that's willy-nilly. There has been a fair amount of work.
Okay, any other questions? We're voting on the resolution. The resolution states that there's a draft of attachment that gives corporate counsel the authority to finalize the actual contract. This contract has an end date, 20 years.
2038.
2038.
Tax year 2038.
And so this is something we've been wanting to achieve in DDAs and TIFAs. So this kind of fits a goal that we've had in on these type of agreements. Go ahead, Shelley.
Yeah, I have a couple of questions.
Oh, turn your mic on.
I don't know where I'm talking, but anyway, so there is an end date on this, correct? this is not like the old-fashioned ones that went on forever and ever and ever, even though there was no downtown, viable downtown. Okay, what happens to the DDA? Is the DDA rolled into this?
No, the DDA will continue.
The DDA, there's an end date for the capture. There's a dollar amount and an end date. Whether the
20 years.
DDA would continue or not, I don't believe that's in the agreement or the contract limiting downtown authority.
So how much are they collecting for downtown development authority, in addition to the 9 million?
In total, I think it's about a $50 to $55 million capture amount. Southfield's up around 45 million over the 21 years, and the county with Parks and Rec is just a tad over 9 projected.
So we have $9 million from the TIF and $9 million from the DDA. Is that correct?
More than that.
No, the TIF is the DDA.
Okay, so we're rolling the DDA into the TIF. Somebody help me out there.
They're the same.
They're the same. Okay, so all of it will end, period, unless somebody votes for it in 2038.
Yes.
So if they put the $9 million prior to 2038, then the county will have the option to renegotiate, opt back in, or have their participation.
Okay, so we kind of eliminated the DDA and rolled it all.
We wouldn't eliminate their DDA.
We don't have that authority.
They're the older one.
We would eliminate our capture.
Okay,
Right.
got it, okay, I guess. Thank you, Mr. Chair.
2038.
Wherever you are.
Okay. Any other questions on this resolution? If not, call the roll on item number 30.
37.
Yeah,
Yep.
okay.
Bowman,
Yes.
Kowal,
Sorry?
Zach,
Yes.
Long,
Yes.
Taub,
Yes.
Fleming,
Yes.
Crawford.
Yes.
Middleton.
Yes, motion carried.
Thanks to
Thank you very
the
much.
committee
Yes,
for
thank you
moving
very
this
much.
up on the agenda for these
Okay.
gentlemen. And I'd also like to thank Dave Beaver and Joella
So,
for their
okay.
work.
Commissioner Quarles wants to comment.
Thank you, committee and chair. As you know, this is a very major opportunity for Southfield as we look at the Northland project. And many of you around the table realize that this has been something on the table for a number of years. So I'm very thankful and appreciate the opportunity and the work that the staff, the departments have contributed to this. And we're going to make this a success. Thank you.
Okay, thank you.
Thank you very much.
Okay. Next, now we are on the regular agenda, and we can follow our script. So we're on item number 29, Central Services Aviation Division, Airport Land Lease, Hangar Exchange. And I need a motion on that issue. Long and Crawford, who are both on the airport committee. Go ahead, Cheryl.
Good morning, Cheryl Bush, Airport Manager. I'm here this morning with the Hangar Exchange LLC land lease. This is essentially a restructuring of the Mr. Hangar lease that we presented in November. It was not executed. The client came back to us with a request to change the name and the term based on a like-kind 1031 IRS program that they wanted to participate in. So there's no financial change, no differences there, just a matter of term.
This jail thing's
And start will be March 1.
Okay. Any questions? Being no financial, I guess it's a contract we have to go. If there's no financial, I didn't know why it came to finance committee, but if it's,
It did change from what you approved previously.
Oh.
The amount changed a little bit just because it was timing, only because of the timing
Yeah.
issue when you have effective date of release.
okay, thank you.
Yeah.
If there's no other questions, let's call the roll on item number 29.
Zach,
Yeah.
Yes.
Long,
Yes.
Taub,
Yes.
Fleming,
Yes.
Crawford.
Yes.
Bowman,
Yes.
Middleton.
Yes, motion carried, thank you. Next is item number 30, Facilities Management and Facilities Maintenance and Operation Jail Cooling Tower Replacement Project. And I have a note that this passed Building and Planning unanimously on, I forget what date, on the 13th?
Tuesday.
On Tuesday, the 13th. So need a motion for, okay, Fleming and Zach. Yep, go ahead.
Good morning, Joe Murphy, Manager of Facilities, here today to seek approval for this project to replace a 31-year-old cooling tower at the jail facility. It is part of our capital plan and improvement plans. So if anybody has any questions from the write-up, fire away and we'll do our best to answer the questions.
Okay. Any questions? And it passed the Building and Planning unanimous, so they were satisfied. So, what is it, planning building? Okay, sorry about that. If there's no questions, call the roll.
Long,
Yes.
Taub,
Yes.
Fleming,
Yes.
Crawford.
Yes.
Bowman,
Yes.
Zach,
Yes.
Middleton.
Yes, motion carried. Thank you. Next is Department of Information Technology, first quarter 2018 development appropriation.
31.
Oh, okay, I already marked that off. Okay, 31, Economic Development, Community Affairs Resolution approving a provision of second brownfield plan amendment for the Iron Ridge project, City of Ferndale and Pleasant Ridge. Need a motion. Zach is moving it, Todd is supporting it, and you want Dan Hunter back in here? Oh, no, okay, there we are. Okay, we already have a motion, so now you guys just have to explain the Iron Ridge project.
This is an amendment to a previously approved project where they were combining parcels, and under the Brownfield Act, we have to bring it back through. For just the highlights on what the project is, this involves two communities of Pleasant Ridge and Ferndale, who were totally supportive of the project. And I'll have Brad just give a highlight.
Go ahead, Brad.
Just as Dan mentioned, this is our second amendment. The first brownfield was passed, and then EDC noticed that some of the parcels in the brownfield plan were adjacent or contiguous with the facility or contaminated parcel, so that's when the First Amendment came through to remove those parcels. However, since that time, the parcels were combined and placed into the brownfield plan, so this is the Second Amendment. The Iron Ridge project is 13 acres over those two communities. The main focus on it is the 70,000 square foot former Walker Wire building that will be redeveloped into offices and beer garden, workout facilities, etc. It's a true mixed-use development for both communities. Both communities are extremely excited about it. It's a $25 to $30 million overall investment with the creation of 200 to 250 full-time jobs when fully completed. There's a housing component on the Ferndale side as well. That'll be a new build once they get moving on construction in the spring of 2018.
Okay, good. Any questions on item number 31? If not, call the roll.
Taub,
Yes.
Fleming,
Yes.
Crawford.
Yes.
Bowman,
Yes.
Zach,
Yes.
Long,
Yes.
Middleton.
Yes, motion carried.
Thank you.
Next, we're going to try 32 again. Department of Information Technology, first quarter 2018 development appropriations transfer. Fleming is moving it, and Long is supporting it. So, 32.
Good morning, Commissioners.
Good morning.
Mike
Good
Tim,
morning.
Director of IT, Jeanette McKenna, our Manager of Internal Services, and Monica Tinsley, our Financial Support. We're here with a quarterly request to transfer from the general fund into the IT fund. This is for work that's already been completed in projects, application development, as well as support of the information technology infrastructure and systems.
Okay, any questions? Yes, Commissioner Top.
I'm just asking how we're doing with our security, since that's your main job.
We're actually, security is pretty significant focus of what we do. One of the great things that we've done recently, and this has been a multi-year process, we have integrated the security practices into our application development teams, into our infrastructure teams. So it's really the job of everybody in the department. It's not just the security. We have a small team that focus on it full-time. They do a lot of monitoring and intrusion protection, looking at people that are trying to get into our systems. We have a lot of tools to help us with that. But again, the big innovation has been getting everybody in the department involved.
And what are we doing in elections? Because we hear an awful lot in the airwaves now about people trying to hack into our election stuff.
Yes, we actually did work with the clerk and the elections team last year, implemented a brand new election system that was partially funded, I believe, by state funds and some federal. And that is it's a brand new platform, completely secured now. The way the information is transferred from each of the cities, villages, and townships. They have new software to handle the ballots, do the ballot design for each of those different voting entities, and the security between them is on a completely separate network, so there's no internet intrusion available for that.
We still use paper though,
The ballots are paper, but they are scanned, and there are some of the areas that are able to do it electronically as well.
If worse comes to worse, you can start counting paper.
Correct. Yep.
Thank you. Thank you, Mr. Chair.
Yeah, when I first read that paper ballots, I'm going back to the old where you marked off a number. And then I thought, yeah, that ballot that we mark and we run through a scanner is a paper ballot. So
correct.
It's a backup. It's a good system, yeah. So, any other questions on item number 32? If not, call the roll.
Fleming?
Yes.
Crawford?
Yes.
Bowman?
Yes.
Zach?
Yes.
Long?
Yes.
Taub?
Yes.
Middleton?
Yes, motion carried. Thank you.
Thank you.
Next is item number 33, Board of Commissioners Tri-Party Program, additional appropriations number 2 for Charter Township of Oxford, project number 5331. And Long is moving it, and Taub is supporting it. Go ahead.
Yeah, good morning. Kim L. Grobley, Fiscal Services. This resolution is requesting the additional $36,606 for Oxford Township's project 5331, which involves the resurfacing of Pontiac Street from Drainer Road to the Oxford Village limit. Oxford Township is requesting to use their fiscal year 18 tri-party allocation, and the Oakland County Road Commission has approved their request. And funding for this is available in the general fund assigned fund balance for tri-party funding.
Okay. Spiz was here earlier this morning. I thought maybe he might have stayed for this, but he he decided not to. But anyway, yes, Commissioner Taub.
Okay, so have we allocated 18's funding yet for road projects? We have.
It's not appropriated, it's within the assigned fund balance. If any tri-party project that comes forward, we utilize the assigned fund balance for tri-party programs and appropriate.
Okay, then we'll take it back and reappropriate it.
We're appropriating it with this resolution.
I understand, but usually every year we put some.
we replenish the assignment, yes.
Okay, that's what I wanted.
Yeah.
Okay.
And
so they're not gonna get 36,000 twice.
That's correct.
Just wanted to make sure.
Yeah, okay. And we changed that a few years ago. We used to just send the assignment to Road Commission. And so that money was out of our control. We changed it a few years ago and put it in our control. But that's why we see these resolutions for tri-party funding come up individually. And so that's why that all happens.
Okay.
Any other questions on 33? If not, call the roll on item number 33.
Crawford?
Yes.
Bowman?
Yes.
Zach?
Yes.
Long?
Yes.
Taub?
Yes.
Fleming?
Yes.
Middleton?
Yes, motion carried. Thank you very much.
Thank you.
Next is item number 34, Board of Commissioners sponsorship of the 2018 International Bocce Tournament at Palazzo di Bocce. Taub is moving it.
I don't know what bocce ball is.
Who's supporting it?
I don't even know what bocce ball is. I think it's like soccer or something, where they wear short shorts or something,
Fleming,
long socks.
it's kind of like you watch the Olympics now, and curling is.
I know what curling is, but I don't know what bocce ball is.
Okay, Chris, you want to explain this?
I don't know that I can explain what bocce ball is.
Demonstration, please.
Hey, I have an Italian background. Bocce is a good game.
Okay, thank you for the help,
Show us how
Mr.
to
Chairman.
Yeah.
I'm here on behalf of Chairman Gingell, who is the main sponsor of this resolution. It's not often we get an international sporting championship tournament here in Oakland County. He's seeking $12,000 for Oakland County to be a sponsor of the International Bocce Ball Tournament that will be held at Palazzo di Bocce in Lake Orion. This is the second time that they've been the host at Lake Orion. They did it the first time in 2005, which apparently was the first time they had both men and women together playing bocce ball.
I have to look this up.
And the first time they did it, they had 18 countries come together from across the world. And this is a sport that I'm learning a little bit about all kinds of things here at the Board of Commissioners. And this is a sport that is apparently growing quite a bit, and looking for this event to be even a bigger success than it was in 2005. So for our $12,000 investment, we'll receive advertising for Oakland County on banners, their in-house TV system, the program book, website, social media for several weeks, and they'll be incorporating us in their press releases and media campaign. We have in the past also, of course, had some precedent of supporting these sporting events when they've been hosted in Oakland County, from way back when the Super Bowl was hosted here in Oakland County, Ryder Cup, PGA Championship. So who knows, maybe bocce ball will be, Oakland County will be known as the home of the bocce ball tournament in the future. So with that, I'd be happy to answer any questions that you have.
Okay. Any questions? If not, call the roll on item number 34.
Bowman?
Yes.
Zach?
Yes.
Long?
Yes.
Tubb?
Yes.
Fleming?
Yes.
Crawford?
Yes.
Middleton?
Yes, motion carried. Thank you. Next is item number 35, Board of Commissioners funding support for Haven Conference for Domestic Abuse Professionals. And Zach, are you moving that?
Yes, I am.
Okay. And Todd is supporting it, so. Okay, we have a motion before us. Go ahead. Commissioner Zach, you
So
can.
I have a guest today. I have Emily Matusik, who's the Director of Special Programs at Haven, and I've had the opportunity to work with her for many years. If you have any questions, I think that the resolution is very specific. I know when I met with the newer CEO, Anna, and she's on vacation this week, otherwise she would have come here to meet and greet. I was shocked when I learned about the preponderance of strangulation in our community. And what really shocked me is not only is it growing, but the danger of strangling, that people can die from it without seeking treatment. You don't see the visible scars, you know, and but Haven has a special piece of equipment that will x-ray and show that. And if someone is strangled, you go from a misdemeanor of other assault into a felony. So they were talking about doing this conference to particularly train professionals, police, whatever, about this issue, how to recognize, how to deal with it. You know, it's the state-of-the-art training. Bringing it to Oakland County, it facilitates our prosecution, our treatment of people in Oakland County.
Wow.
And we're adding some additional money to the sponsorship of this program. I think the total cost is somewhere around 20,000 or 18.
About 18,000, yep.
and we'll be able to present to about 150 people over a course of 2.5 days, mostly first responders, police personnel, judicial personnel, and hospital personnel.
So this is in addition, I just want to, remind you, so one of the things that Haven does in Oakland County are these nurse examiner, SANE, they call them, and they have certified, specially trained nurses that do a forensic examination following some type of assault. And they're done in a couple of facilities throughout Oakland County. And historically, the Board of Commissioners, it's now in the sheriff's budget, we do fund money toward these exams. Prosecutor loves it because, again, we're collecting forensic materials that can be used for prosecution. We all win by this. So this is an additional piece to that.
Okay. Commissioner Top.
I think it's wonderful. By the way, I did start that program at the Board of Commissioners. The forensic exams a million years ago.
Thank you.
You're welcome.
I'm
hoping some of this gets out to the public as well.
Oh, absolutely.
I think that some kind of campaign needs to be told because sadly enough, oftentimes there isn't even a first responder. Okay? And then 2 weeks later, you've got somebody dead on arrival. So I'm hoping that this will get out not just to the first. They're very important, obviously, the nurses and doctors, but also the general public.
Oh, yes, and other human service agencies that would have contact with survivors.
Are you going to include mental health in that?
Absolutely, yes.
Thank you, Mr. Chair.
Okay, any other questions? We have a report because it's it's bold on your iPad. It's Haven Strangulation Prevention. We're adding the word prevention conference. So I need a motion. Yeah. When you're working on something, Liz, you get so involved you forget that wording needs to be kind of a little more clear. I need a motion to accept the report to add the word prevention to the conference. Bowman is moving it. Taub is supporting it. Call the roll on the report.
Long?
Yes.
Taub?
Yes.
Fleming?
Yes.
Crawford?
Yes.
Bowman?
Yes.
Zach?
Yes.
Middleton?
Yes, motion carried. Now on the fiscal note, item number 35, call the roll.
Zach?
Yes.
Long?
Yes.
Taub?
Yes.
Fleming?
Yes.
Crawford?
Yes.
Bowman?
Yes.
Middleton?
Yes, motion carried. Okay, next we are
Thank you,
at
Commissioners.
item number 36A. Great Lakes Water Authority Class Action Settlement memo dated February 5th, 2018. And are we going to take A and B both? Great Lakes Water Lake Authority current and legendary legacy business issues facing the Great Lakes water. And that was a memo that was sent to us last meeting.
Communication item on the last finance committee
Okay.
agenda.
And this is a receive and file.
It will be a receive and file, Commissioner.
Okay. Go ahead and start your comments.
Okay.
I guess I would say your disappointments.
Well, yeah, there is some disappointments, and there's a real big disappointment right now that we're talking about here at the Great Lakes Water Authority that affects your communities.
Yeah.
I had previously brought this listing of business issues to the Finance Committee here and updated it at the end of my term as chairman at the board of Great Lakes Water Authority. Now I'm a director, if you will. So I thought that I'd provide the listing as a transition from my chairmanship of Great Lakes to that of the new chairman.
Who is it?
Freeman Hendricks from Detroit. And to that end, I wanted to make sure that the board understood, the listing of issues that were outstanding,
if for no other reason, then little action has been taken on these over a 2-year period of time. We've been in place for 2 years and 2 months now, and to some extent, many of these items have been on the list since that period of time of the launch of GLEWA. So I wanted to make sure that people understood the list and understood the issues and the issues that needed to be resolved. In yesterday's meeting, I informed the board that I have no intention of approving the capital plan, the operating budget, or the rates or charges for this year as 1/6 of the vote of something that requires five out of 6 votes, unless the critical issues in this listing are resolved. And unless you think I didn't tell them before, I told them in November. So to that end, you know, some of these issues are fairly substantial. On the first item I'd like to chat about is the lease payment for $25 million. The lease payment, apparently GLEWA has paid DWSDR $25 million more than the agreed upon amount. Well, it occurred because that the original thought was we would start GLEWA on July 1st, 2016. Unfortunately, we were unable to solve many of the business issues by that point in time and delayed the launch until January 1, 2016. The problem was the fiscal year 2016 budget had a $50 million lease payment, which included the full year. And unfortunately, it gets fairly complicated, but effectively the GLEWA paid that $25 million, even though it wasn't even in existence, if you will, until the lease became effective January 1st. I caught that. On the Thursday before a Friday audit committee meeting, when they shipped off the draft financial statements on Thursday evening for Friday morning discussions at an audit committee meeting. And I shipped something off late in the evening on Thursday with a number of other comments, if you will. The board, the audit committee did not approve the report because we had a number of questions, if you will. But management released the report with a $25 million error in it on that Monday, regardless. And to that end, this has been an issue that has been known since late July. And the reason why it wasn't identified here earlier is we don't get regular financial information. I am still waiting for the 2017 draft financial statements. We have seen no interim statements at all. And we're running an $800 million organization. And we have not changed that effort. There's been a lot of promises, but it hasn't occurred. The accounts receivable runoff issue is one where the Great Lakes Water Authority assumed the liabilities of DWSD and the receivables at that point in time, which makes sense because we were ultimately the successor agency, if you will. To that end, how and why how the DWSD collects those receivables and remits to us as they retain the detailed accounting records for the receivables has been troubled at best. The details of their accounting system relating to accounts receivable is, I won't even characterize it in any way in a public meeting. The long and short here is by the time we get to June 30th, 2017, they have pretty much run those receivables off. An analysis that we received in early January on the balance of accounts receivable indicated, however, an issue, and I did provide an update to you on the accounts receivable runoff, is we've discovered now that the city of Detroit, DWSD rather, owes Great Lakes Water Authority $103 million much of which is delinquent, because we're finding out that the uncollectible amounts that they have from their customers, their residents and their businesses, can't be paid in cash, obviously, to GLEWA to cover our debt service and the costs relating to their piece of the operation. So they owe us $103 million, which is essentially being treated almost right now, when we discovered this, as a line of credit. GLEWA is not a bank for DWSD. And unfortunately, as I've done a calculation on that effort, and it's dependent, I did a real quick and dirty one. The cost of that on just on a basis of money is somewhere between $800,000 to somewhere upwards of about $3 to $3.5 million in lost investment income by virtue of having our cash, which we paid for on their behalf, tied up in receivables we've not collected from DWSDR. The transfer of the water mains was an issue that was more or less a convention that we had to address. As you know, we assume certain responsibilities for Great Lakes Water Authority with regards to the physical structure, the regional leased assets, if you will. But DWSDR maintained the retail piece of the asset. So there's a connection between somebody's home all the way to the sewer plant or to the water plant. There's a demarcation point that had to be decided, somewhere, so that the two pieces, are bifurcated in the responsibilities. We set that because they have 3,000 miles of sewer system in Detroit for water and another 3,000 miles for sewer. It was impossible at the time to go sewer by sewer and piece by piece to deal with this issue. We set a convention up. Anything above 24 inches was a leased asset. Anything below was DWSDR. We're finding, however, that we have on 24 and above mains, there are only DWSD customers. So the problem here is that GLEWA is maintaining an asset. This would include something like a sinkhole or, if you will, a main break. So we would repair that on GLEWA's nickel. We have been trying for 2 years to resolve this particular issue with DWSD, and we now find ourselves in arbitration over this issue. It will not have, ultimately some or most of the mains relating to the ones we've been able to identify will shift to DWSD's responsibility to maintain them. They will probably have to add staff. I would submit that GLEWA probably will not have to add staff, but would be able to take those people and focus them better on maintaining what we have as our issues in preventative type activities. But it's a fairly significant issue for DWSD. And we are in a arbitration on that issue. Arbitration hasn't started. The GLEWA board approved that in late December to go to arbitration. On another issue, billings by DWSD Water to sewer operations, we have a situation where we have water production plants, a leased regional asset, transferring over a lateral, the pipe if you will, a leased regional asset, to a sewer system, leased regional asset. Sewers need a fair amount of water to operate, if you will. So it's regional in the process. The problem is somewhere along that way is a meter that DWSD has, and they have been billing GLEWA as if they were responsible for the retail operations of that system. And that transmission of water. It's not true. Now, we've been trying to get this thing quantified for almost 1.5 years. Passive-aggressive behavior is something we fight daily down there. I have in here an estimate that was provided to me in December that memo on the quantification of the amount is $10.9 million in your update. And we need a credit back or a payment back from DWSD. The problem here is, as you may be finding, if you started to add up some of these issues on what I've just totaled, is DWSD doesn't have the cash to give. Otherwise, they wouldn't have a $103 million delinquency with Great Lakes Water Authority, or 10.9 they owe us and can't pay on this issue, or dealing with other issues that I've identified as well, including the lease payment. So they owe us 10.9 on that effort as well. Debt amortization, these are all issues that I'm saying I want resolved before I provide my vote towards this year's arrangement. The debt amortization as of June 30th, or as of January 1st, 2016, remains an open issue. As we agreed upon the amounts of the debt split based on a fixed asset proxy, discussed later in the memo. I'm not going to go into it. And we split the debt between DWSDR and long-term debt bonds, if you will, and GLEWA. But we couldn't come to agreement as to how that debt would be amortized. You know, as the payments are being made, how would they be amortized over what piece? What piece is principal, what piece is debt service, and, if you will, over what period? That remains an open issue. And yet we're now, you know, we're into our third year and considering our fourth year's budget. Unresolved. I&E funding. I&E is improvement and expansion. It's essentially revenue-produced capital. In other words, cash that's created from the system to be used in lieu of a bonding. And to that end, earlier financial information, not updated yet, in the summer of 2017 indicated that the sewer, I believe, is in a negative position. In other words, if it's in a negative position, the sewer's Great Lakes Water Authority assets have been used to pay DWSD capital. I have, you know, obviously significant concerns on timely, accurate, and relevant financial information. At Oakland County, we close our books in 30 days. Our books for June 30th, 2017 are not closed. It took 13 months to get the audit report out, which was wrong because of the lease payment, last year for June 30th, 2016. This is fairly typical. They do not get quarterly reports as you do. We do not publish monthly financial statements of budget to actual. I have yet to see a budget to actual statement. And I've been around that place since 2013.
They put in new software, didn't they? Or
yes, they did.
And which was supposed to take care
of
that?
Yes, it was. And we have, well, I don't know whether it did or didn't. The board has not seen any of the benefits arising from that. Makes a job of trying to run an $800 million operation a little bit more difficult and requiring a bit more artful effort. I have a number of other issues on capital improvement programs, shared services, and so forth, but I'll talk a little bit about Highland Park. Highland Park owes GLEWA about $36 million in unpaid bills going back 4, 5, 6 years. We're in substantial litigation right now. The equivalent amount of the surcharge, because of a court order that exists. The court order basically says DWSD pay, on the sewer side, DWSD pays their bad debts. Suburban pays its bad debts. Highland Park is considered a suburban portion. So we pay, the suburban entities as a group, pay for the Highland Park's failures to make their payments on their sewer operations. That's a surcharge of somewhere between 2 to 3% on your sewer bills that are billed to to the local units.
Is Highland Park charging their residents a sewer charge yet?
They are, but unfortunately what happened is culturally what it happened for about a 2.5-year period is they stopped billing their residents. Essentially it was free water. It became culturally ingrained you know, in the effort, so that when they restored the billing process sometime in late 2015 calendar, you know, people hadn't been paying for years at that point in time, and there was no repercussions. They weren't shutting off, you know, the houses. So why bill? They're paying they have been able to get to a point where roughly half of what we bill them is coming in receipts. We're increasing this receivable at a pace of somewhere between $300,000 to $500,000 a month. And we thought this was coming to a conclusion because the state Supreme Court, state and U.S. Supreme Court rejected their litigation. But on Monday, Judge Murphy, who is in charge of one piece of the case, this is both in federal and local court, has put on hold our judgment levy that was supposed to be on the bills as of July 1st. Now understand the judgment, $36 million that they owe us, if you will. The taxable value of Highland Park in totality is $115 million.
Oh.
Think about that.
So we may own Highland Park.
Well, we'll have a significant investment in Highland Park, I suppose. The long and short is that the judge has put this on hold again. And that is the only lever that we have in an ability to collect that revenue. So we're more to follow on that, but this is a continuing saga, and we're challenging it. I'll let you read the rest or ask questions, if you will, but I'd like to hold on. I'd like to go into the class action settlement, if I could, that I'd sent out here earlier, because this is a particularly egregious problem.
This is stormwater.
Well, this is called Michigan Warehousing Group, if you will. It's the stormwater effort. There has been an attorney firm and now several others that have been going around suing local units for stormwater charges and the methods in which they're billing stormwater. In Oakland, Waterford, Ferndale, Royal Oak, and Birmingham, I know, have lost cases in this effort. Ferndale, I don't know how much the amount was, but I know Royal Oak was $2 million. And the same firm has a lawsuit against GWK as well, which would be the communities down there in southeast portion of the county. The problem I had with this effort here is the board knew nothing about this particular lawsuit until such time as Brooks Patterson sent me an email on November 7th in the evening with an attachment from his friend that had an attachment to his email where he discovered in a class action newsletter that DWSD and GLEWA had settled a lawsuit for $29.5 million. That was the first notice that we knew about this lawsuit.
Is that Brown?
Well, hold on, please. You know, the long and short is I raised the issue because we had a November 8th meeting. I shot off some emails when I got that, you know, and got some information in advance of the meeting that day on the 8th. Our corporation counsel for GLEWA, and I wanted to go into closed session on this issue, fought tooth and nail to try and stop going into a closed session because he was a party to this whole matter. And to that end, ultimately, I prevailed, and we did go into closed session for 2 hours on this issue. And I wasn't a pleasant individual. And to that end, you know, more information flowed from this effort after. And I've outlined the process of what we've discovered. First of all, we got a copy of the, you know, all the documentation that they submitted, I think, from the beginning till the end on this case that I asked for. this particular case, and I agree with it here, is GLEWA assumed the liability for this case as part of the lease agreement. The problem here is that the lease agreement doesn't specify cost allocation and who's responsible to pay for those Notwithstanding that, GLEWA administration, unbeknownst to the board, and with no action that we took, settled this case at $29.5 million along with DWSD, with Great Lakes Water Authority paying half the cost, $14.75 million. And to that end, here I am, November 7th, finding out about this just before the board meeting, and I get the settlement agreement that was signed by Gary Brown, who is the DWSDR director and a GLEWA board member, on August 31st, 3 months earlier. And no mention of it. None. The Board of Water Commissioners approved that settlement agreement in mid-August. And our people hired an attorney, GLEWA, in May to participate in the settlement discussions leading up to that August settlement. They've known about it for 6 months and didn't tell us. And we were fighting for a 6-month period of time throughout the better part of the early part of 2017 on sewer share allocations on a lesser amount. Now, we have, the ultimate settlement here was a $10 million payment of the 29 on 12/31 and another 19.5 as of July. Split 50-50, that would be $5 million coming out of Great Lakes Water Authority. We voted on that as a board on, in late December. Now, we've had a board meeting on November 8th, November 29th, closed session, 2 hours again. December 10th, I forced the meeting to be an open meeting over the objections of Detroit. And then December 21st. On December 21st, there was a 4-2 vote to pay our share of the $10 million on by December 31st. Now, the principal piece of the $10 million is being used for the $7.7 million of attorney fees in the settlement. Oh, yeah. This was all withheld from us. Now, they voted on a 4-2 basis. Oakland and Macomb objected, obviously, to pay the $5 million, and Wayne, the governor's rep in Detroit, voted in favor of it. We move on to, in the third meeting on December 10th, and of course, I've been asking, where did you get the authority to settle this? Because the board expressed no authority to the administration to allow them to settle anything. And what, how did you come to this conclusion? There's a whole series of questions here. But one of the attempts is in the justification of this effort, was we had a prior settlement. We had a precedent for not bringing it to the board. I said, what the hell? What are you talking about? Apparently, United House of Prayer was used in the fire line maintenance, fire hydrants, if you will, where the same attorney firm used the same basis, and they settled in 2016 for a $5 million settlement, $4 million of which was paid for by GLEWA, and they didn't tell us. And that was being used to justify why they didn't have to bring it to the board.
Because they didn't before.
They didn't before. I went nuts. Now, the problem here is that Michigan rules of professional conduct, which guide the performance of attorneys, require quite clearly that the lawyer is also required to notify the client promptly of all settlement offers as well as settlements. Our attorneys failed to do that, obviously. So they're in violation of their own canons. Notwithstanding the fact that they hadn't even, noticed us. Fast forward, we went into arbitration. We have voted on the 21st of December for arbitration on who is to pay for this. Notwithstanding that we've already fronted $5 million, of this effort on, in this regard. And then on the January 10th meeting, we put the United House of Prayer also into arbitration. Since then, Detroit has, while I was on my term of still being board chair, I asked for an outside opinion on this matter as to who was responsible for the funding from Dickinson Wright. Dickinson assisted us in the writing of the lease. They issued that opinion and gave it to General Counsel. I asked for a copy of the opinion. They have refused to provide it.
And you were chairman of the board?
Oh, yeah. You bet. And they say it's privileged information. Well, it's privileged information, if you will. I have issued a FOIA, a board member issuing a FOIA for their own administration withholding documentation. I'm about to have it denied.
And Bob, this administration reports to the board.
Well, of course it does.
Well, who appoints this administration? I mean, how do they get in the position that they can do these things when they report to a board that has authority over them?
Because they apparently have 3-3 votes. Oakland, Wayne, and Macomb they could stop it. This is passive, aggressive behavior at its finest.
What justification does Wayne, Detroit, and the governor's rep have for some of these decisions?
Well, in the case of United House of Prayer, that matter settled, and the GLEWA board obviously had the responsibility, or not responsibility, the authority to settle these cases because they did, and it was paid. And by the way, it's a closed issue, and that's I was going to get to this, but Mr. Brown has issued a memo essentially saying, we don't want to go into arbitration because that matter, the United House of Prayer, is already settled and paid for and behind us. That's $4 million. This stuff is going to be coming out of your rates.
Sure.
The issue here is they say that it's a client work product and it's a privileged document. But the privilege runs to
the clients.
The clients. Which is us. And they're very good at tap dancing. And unfortunately, the governor's rep is voting with them. So I actually attempted at the January 10th meeting to introduce a resolution drafted by Poisson to have board members release documents of the administration. It failed on a 3-3 vote.
Who's the governor's?
Yeah, that's what I asked. Who is it?
Craig Huppy from Ypsilanti area. It failed on a 3-3 vote. Right now, I suspect we're heading into arbitration, but think about this for a moment. The same GLEWA management that exists today were the management that managed the place as DWSD before the GLEWA. So they were a party to the discussion and issue relating to the problems in Detroit's billings. Effectively, the most significant one is 22,000 acres of property wasn't billed for stormwater, while others were billed the full cost. I mean, there's a number of other complaints, but that was the principal one. And therefore, it failed the Bolt test of being proportional amongst the entire population. So to that end, DWSD management is now GLEWA management. GLEWA management negotiated with DWSD outside of any suburban involvement in this effort, and have come to a conclusion and have introduced and through the court these records now that bind at least us into the payment of this payment process. The cost allocation is still open, but these are the same people here who are going to be going into the arbitration on behalf of the suburbs when they've already negotiated a settlement with DWSDR.
So what do we do?
Well, we're having our discussion with our corp counsel, and I put them on notice that quite frankly, this issue, we're going to hire our own attorney, and I put management on notice at yesterday's board meeting that a lawsuit's liable to be coming on this issue. I shouldn't have to do this, but I am.
Okay, I got a couple
That's
questions.
pretty much,
Yeah, okay.
the gist of it, but it's outlined in some fair detail in this memorandum.
Okay, Commissioner Taub and then Commissioner Fleming.
Okay. So it seems as if the governor's person, can you spell his last name, please?
HUPY.
Craig?
Craig.
And where is he from?
Ypsilanti, I think.
Are they part of our system?
Yeah, we have, the makeup of the board is 2 from Detroit, 1 from the 3 counties, and 1 for the areas outside the 3 counties. So he is representing those areas outside of the counties. Ypsi is
Yeah.
I think that's where he works, but again, we have, we don't just stop at the tri-county border. We have,
Yeah.
things in other counties.
Okay, thank you.
Okay, Commissioner Fleming.
Hey, Bob, I'm glad you're there, otherwise we would not be getting this information. But the bottom line is, the GLEWA administration is out of control. The dysfunction is the same as DWSD, and there's no accountability. The bottom line that I'm concerned about for the residents of the suburbs, we went into this, as GLEWA, we thought we had a cap on our water rates and weren't going to exceed certain amounts. How is all this mismanagement going to filter down through to our residents and to the suburbs and affecting our water sewer bills? You said maybe 2 to 3% just because of Highland Park not paying.
That's right.
But we got a much larger problem than that, So how does this all, if you can put a number to it, because that's what people are really interested in. How does all this mismanagement, we're going to be paying for it. The suburbs are going to be paying for it. And how do we keep it?
No, we'll be. You are.
We are.
Have been.
Yeah, and have been. But what can we expect to see in the future as far as our rates increase?
Well, if you go into the legacy section of this effort, just on the fixed asset write-offs and the swap termination loss, which ran about $1.1 billion in payments, if you will, swap loss over a period of time, as well as some of the $1.1 billion. Those 2 issues in the memo are effectively a surcharge of about 10%.
10%?
Alone. And that's exclusive of Highland Park, for which you got no benefit. No benefit, 0. On this particular issue, it's management's position, because they're not including this as part of the upcoming rates and charges, that it's not a problem. The reality is we're going to be paying out we paid out $4 million, and we'll be paying out another $14.75, or about, I don't know, what's that, about $19 million? The reason why it's not an issue is because we're sitting, a separate issue, it's in there, is that we have $625 million in cash devoted for capital programs on a $1.4 billion 5-year plan that we're spending at a pace of $79 million a year. So the reason why it has no effect on your rates currently, but for paying $19 million out, is because the bottom line is we use whatever's left over, or bonding,
Okay.
you know, to deal with the capital program. So long as the capital program isn't disturbed, it's not an issue, according to management. But paying 19 million out will have an impact sometime in the future on your rates. Don't kid yourself.
Oh, yeah.
The reality here is that the management literally spent on a $703 million 5-year plan on the water side of the equation, $7 million for the 6 months ended December 31st, 2017. That's a 50-year spend pace on things that is absolutely critical. 30 million on the sewer for that 6-month period. So they're still on pace to meet the 79 million. That's 8 years spent. Do a little better on the sewer side. But we have $1.4 billion worth of needs, and when you read the detailed explanations of these things, they're frightening on the deferred maintenance. Frightening.
And all that's underground and nobody sees it,
That's
so
right.
it's not an
You'll
issue.
see it when it creates a problem.
Yeah.
But the problem is we're not spending at the appropriate level. And the reason why it isn't affecting your rates currently on this Michigan warehousing issue is because we have sufficient cash that we can't spend, apparently, for a number of reasons. And the best we've gotten so far is that for the last 2 years, we're assembling a team and dealing with some of the prior issues and trying to clarify the projects and the prioritization. That's the best excuse we've got as to why the spend in the last 18 months isn't anywhere near the pace it needs to be.
Prior to taking this over, didn't they have projects that they bonded for even, and then never
sure.
completed? I mean, and they had a whole slew of those.
Well, that was 550, that's part of the fixed asset write-offs, if you will, about 550 million worth.
Okay, any other questions? Yeah. Any other questions for Bob? Because we're going to go into another one that's going to keep his blood pressure up.
I took a double dose of my blood pressure medicine this morning,
good.
so I'm okay. I'm flying.
Okay, we have a motion to receive and file. Oh, we need a motion to receive and file Bob's report. Long and Fleming. So we'll move to receive and file the update on Michigan Great Lake Water. All those in favor signify by saying aye. Those in favor signify by saying aye. I need some ayes, Tom, and aye. Okay. Any opposed? If not, the motion to receive and file is passed. Now, Bob, we go to the other item on other business, is attention warning. It's on the state's budget office determination that recommended Michigan's indigent defense grants. Need a motion to receive and file this report. Todd is moving it. Crawford is supporting it. Okay. Go ahead.
MIDC has been brought to you on a number of occasions, so I won't trouble you with explaining it yet again. Mr. Poisson has indicated on a number of occasions this is going to be a costly effort. The original legislation passed after the first round failed. Was about 2014 and promised to pay for the incremental costs under Headley as a condition of the passage. It's actually included in the legislation. And as a result, it passed. The local share that we will be responsible for were the 3 years prior to the passage of the legislation averaged less the amount we got for reimbursement of any costs we might have been able to get out of the plaintiffs. That is standard grant accounting 101. And to that end, that was fine in terms of our effort because the increment would be paid for by the state, as promised. Shortly, about a week ago, we received what is the intent of the Senate Budget Office, which is attached, if you will. And the intent now has two changes in the law, two principal changes. The first one here is moving away from what we actually spent on indigent care, or indigent defense, separate issue. Long and short is they have used an amount which is the average amount paid by population at $7.25 per population. So we have 1,240,240. 725 is about 9 million, if you do the math. So we would have to spend our first 9 million towards this effort, not the roughly $1.8 million that we've been spending in the past, on our nickel. And that abrogates the original intent of the legislators when they said that they would pay above what we've been paying in the past, and in accordance with EDLI.
Yeah.
Second issue here is that not only is that a problem, we wound up, to the extent that we mined and were able to secure reimbursements from the plaintiffs, from the defendants. I got all these cases going on right now on Michigan Warehouse, the United House of Prayer, and the whole thing. Long short, from the defendants, we would wind up picking up about, in the past, about 890 million, 800, again, millions, 900,000 or so. I'm working with millions and billions over there and something different here.
That'd be 10 million.
Well, the long and short here is that it would be upwards of that. The new law says that basically that the state retains 90% of what we mine.
Right.
Well, folks, why would we mine it? You know, to that end, you know, they're allowing us to keep about 90,000, which would be one position for this entire county.
Yeah.
Under Gosling.
Yeah.
Long and short here is those two changes are significant, and that is just for phase one. Remember, we got 4 more standards that come in, you know, this year, and a couple of those standards are worse than what we have seen already. Now, the state's governor's recommendation have already anticipated the recovery of the reimbursement of some 15 or 16 million in his budget message. So he's assuming that's already going to be passed, and he's supportive of it. They have rejected our first phase of the effort right now. They have taken out the prosecutor, if you will, the prosecutor's request. Remember, when one attorney is there for the defendant, the prosecutor should be there for in the state, if you will, which makes ample sense. They rejected that. So that's coming out, they anticipate that coming out of our nickel. They've also rejected renovations in Clarkston District Court, which make it very difficult to honor the standard with regards to client confidentiality. There's no room. There's no room. It just doesn't have it in that facility. So they've rejected that as well. So that's going to be a bit of a problem operationally for that court. And we're seeking a waiver from them to make sure that they don't come back and said, you still have to do it, and we're not paying for it. I don't know whether we'll get the waiver or not, you know, under this effort up there. But right now, when we got this effort, we put together an immediate notice. Mary Ann here did that, and to that end, shifted up to our legislators to let them know what's going on and our objections to this effort. Mary Ann, did I kind of cover it?
I think you did, yeah. Just to let you know, there were 134 funding units that submitted compliance plans. They only accepted 16 out of the whole state. They only approved 16. So the rest of us have to go back at it. 30 days after it was rejected on January 1st, we have to submit our second compliance plan on February 20th, and we're prepared to do that. We met with Marla McCowan from the MIDC, resolved a lot of issues, things that, construction projects that she did approve and things like that. But they're pretty much holding fast on the prosecutor thing, but we'll be rejected again. The MIDC made it a critical stage. Under the state law, a critical stage is an adversarial proceeding that requires both sides. It's as simple as that. And that we will be ready to litigate because it's litigatable. We have case law all the way up through the Supreme Court that a critical stage, what they've called it, is an adversarial proceeding. And the judge and the attorney, under rules of ethics, cannot engage in discussions without the prosecutor there. So it's simple as that. And they know that. They just think, really, we are a rich county and we should just pay for it. They really say that kind of stuff. You know, you guys have the ability and you've got the tax base.
On the other ones that they rejected as a prosecutor an issue on almost all of them.
There were 6 funding units, 4 counties that added prosecutors and 2 municipalities, and I'm not sure who they were, but there were 6 that had prosecutors and the rest didn't.
Which counties, Mary Ann?
Wayne, Macomb, and Oakland, and I think some county on the west side.
Probably.
I don't have that.
Kent. Probably Kent. Yeah, I'm thinking Kent. Okay.
And then there were a few
you know,
district
MAC has been, if I may.
Go ahead.
Yeah, Michigan Association County, they're livid. I mean, literally livid. There isn't a county in this state that's happy with the situation because the small ones, they don't have the money to do it anyhow. And they certainly don't have the facilities to do it.
Every funding unit will be subject to the per capita thing. So whatever the per capita is of Pontiac, they're going to have to do the $725 per, person in their city. Oak Park, same thing. So it's not just the county. I mean, we're unique because we have
4.
We're unique in the state. We have 4 district courts that comprise 3/4 of the county.
Right.
So that's unique, which is why ours is very high. But a lot of these municipalities don't have 2 nickels that they can pay $7.
So Southfield that has its own courts and
Oak
Park,
Farmington,
Ferndale,
yes.
they're going to be
Waterford.
Waterford,
Not they
Hazel
declare
Park.
themselves Highland Park and does not pay it.
Yeah, Pontiac, yeah.
Well, that's the most concerning one about the governor's proposals, is that all funding units will have to, their local shares will go up to that level of $725 per capita.
So if I'm going to pick on Oak Park, I don't want to pick on them, but so let's just say they have 2 or 3 prosecutors there. I don't know how many they have. I'm not certain. So those people are going to have to be on duty because you're going to have the indigent defense people on duty because they have to be arraigned in a certain period of time, yes?
The issue is no, they don't have the prosecutors there right now because it's not, as Mary Ann has indicated,
right.
This is not a critical stage in the process, and generally, when you're arraigned, you don't have the attorneys there from either side.
I understand that, but henceforth, I'm talking about henceforth.
Yes, going
okay,
forward.
So you're going to have to get somebody, because there's a period of time frame
You'll
there.
have to have them on weekends.
Yeah, on weekends, yes.
Sure.
Sunday, Saturday nights, holidays.
And as Judge Martinez said to me at a meeting, you have to have them in the hospital on a Saturday night for somebody who needs to be arraigned in a hospital.
The prosecutor estimate is about $2.2 million of our request because of.
Is that our prosecutors but not
ours?
Ours.
It will be it will be the felony prosecutors in all of the county district courts, even the even outside.
So that includes Oak Park and Pontiac. I'm making that up, or.
But then the local funding units will also have to have misdemeanor prosecutors there for their city cases.
Okay, that's what I meant. Yeah. Okay, thank you.
Okay, Commissioner Zach.
That's what I wanted to clarify. So the 9.8 million is county, and then the local funding units.
They got their own headaches.
Yeah, right.
Another amount, $725 per head.
Yes.
That lives in their city.
Yeah.
Yes.
Wow.
It's not going to cut it.
And then, oh wow, okay. And then the issue of, would that become how do you administer that? How do you charge?
Well, that's not that hard to administer in terms of the effort because you spend the
population.
We face the same issue with, say, child care facility because it's 50-50. So dealing with that effort is not. Yeah.
They won't fund you until you reach that amount.
That's right.
Then you get state money.
That's right. So you would be submitting your report in, identifying your cost, but until you actually get to that cap, it doesn't trigger any payments back.
Yeah, so we have increased program requirements that will have increased costs. so that will force us to spend that money eventually.
Now remember, this is phase one. This is just the first 4. We got another 4 coming in terms of standards.
They did approve the countywide CLE training through the Oakland County Bar
We
Association.
should clarify, it's
Yeah.
not approved, that's what she's going to
Well,
recommend.
she's gonna recommend.
Yeah.
So we don't know if it's going to be approved or not by the
Yeah.
MIDC.
This is an administrator. Had no authority to approve anything.
Yeah.
The only board that can approve it is the MIDC board itself. And these people have done 180 Airbus's in midair on a lot of this stuff.
But we believe that they'll approve whatever she recommends.
We're certainly going to press her, you
Well,
know.
we know we're gonna end up in mediation because they will not approve the prosecutor costs and we're gonna go forward with that.
Okay, so let me just understand this. If a small community doesn't have money to build a facility or some kind of room or rooms where people, they're gonna just have to pay for it themselves.
Or they can ask for a waiver.
Or they can ask for a waiver? Well, that's, yeah, lots of luck.
Isn't 36 district court?
Yeah, they gave 36 District Court a pass because they have a plan to build another building in 2 or 3 years.
Yeah.
Where's
That-
36?
The
Detroit.
Detroit. Oh, Detroit gets a
So-
pass.
Yeah.
Yep.
Probably be added into the
Now,
legal
that
stuff.
probably, that court is probably one of the more busy courts in the.
Okay, is there any other questions to ask Bob on indigent defense? If not, thanks for the update. We have a motion to receive and file. You got anything else, Bob? Okay, the motion is already here to receive and file. All those in favor signify by saying aye. Aye. Opposed, the same. Motion carried. Is there anything else to come before the Finance Committee today? If not, without objection, I declare the meeting adjourned.